Good afternoon, everyone. As you can see, we're coming to you from a little bit of a different location today here, still at the world headquarters of Berenzweig Leonard, LLP, here from the wonderful Cathedral conference room today. But welcome to the November edition of the GovCon HR Round-Up. It's great to be with everyone. Since we got together in October, two major developments, two major settlements that have had a huge impact on my life personally. The first one being, obviously, the end of the government shutdown, because we weren't going to have this if we were still in shutdown. I was going to boycott as well. The other one was YouTube TV coming to a settlement with ESPN. Because I'd gone 2 weeks without ESPN, and both of these stalemates were starting to weigh on me.
That's right. You're a Philadelphia Eagles fan, so you need to watch. For us, we wouldn't mind a blackout here. We've all prayed for the Biden. Now it's coming this week.
But I come here today a much happier person that the shutdown is over and that ESPN is back on YouTube TV. So all is better with the world. But great to have everybody with us today. My name is Joe Young. I am the president of GovCon Pay. We are the only outsourced payroll and HR provider focused exclusively on serving the government contracting marketplace. As I said, we're coming here again from the offices of Berenzweig Leonard. Before I introduce my distinguished co-hosts here, always want to recognize our sponsor, the great folks from Berkshire Associates. If you're not familiar with Berkshire, they are HR compliance experts who've been supporting companies for over 50 years, providing compliance services and technology for organizations looking to build their ideal workforce through compliant, non-discrimination services, workforce analytics, and pay equity expertise. So a special thank you to Berkshire and any Berkshire clients and guests that are joining us today. So before we get into our topic today, gentlemen, for any kind of first-time listeners here, why don't you kick us off with introductions? Seth, you want to start?
Sure. Hi, everybody. I'm Seth Berenzweig. I'm a co-founding and co-managing partner of Berenzweig Leonard here at the firm, and I help lead our corporate and transactional practice, and also on our business formation and litigation practice.
And I'm Declan Leonard. I'm Seth's law partner, also co-managing partner here at Berenzweig Leonard. I head up our firm's employment law practice, and we've got an event tonight where we were told to dress holiday chic.
I have some accessories still for this.
Oh, you do. And then there's
it's gonna be a surprise.
This is the best I get for holiday chic. So hopefully I'm not good with these these newfangled.
That is a new category.
Yeah.
It leaves us all a little confused.
Seth always wears holiday chic, so it's not really.
We just don't know what holiday means.
I'm going to put one plug in for Todd Castleberry and BLC Digital Strategies. I know we're not in the studio, which is really literally just directly across the hallway, but we found out because of a power surge that it messed with the microphones, and how quickly in a matter of 5 minutes did they set us up over here. So that's why we're over here.
This comes to you only with the great work of the people who are not on camera. So yes, thank you to our teams behind the scenes very much. So today's topic, this month's topic, we're going to get into some conversations around year-end reviews in general. Obviously, it's that time of year for a lot of companies. But before we kind of jump into our topic, we would be remiss, I think, without having some commentary maybe on the big news that's happened after the longest government shutdown in history. So, Seth, what are some thoughts as far as what you're seeing with clients and just the ramp back up from what we've been experiencing?
Well, for those of us who live in Maryland who need to drive into Virginia, there's no clear indication of that the government is back, because then that the traffic is also back. So the Beltway pavement is back to taking a beating. But it feels like we've gone full circle here in 2025. We started with a new administration, DOGE craziness, and the longest government shutdown in the history of Washington. The good news is that we're back. The shutdown is over. Everybody's back to work. Everybody's ramping back up again. And it's time to re-engage with the workforce, which is just in time for reviews, which is very timely for us because we're talking about year-end reviews and things related to and evolving in that space, including some of the requirements and best practices. So it's been a heck of a year, a lot of ups and downs, but I think safe to say that hopefully we're gonna end up on a very positive note.
In last month's roundup, we talked about, the impact of the shutdown. We talked about furloughs, things of that nature, how that impacts your company from an unemployment compensation standpoint, from a benefit standpoint. So I suspect those that are listening here will have varying degrees of sort of getting back online. Do you have to re-onboard people that maybe were no longer on benefits, things of that nature? So, it's probably a mixed bag of what you've had to do. Hopefully it's been pretty seamless for a lot. That's what we're seeing with a lot of our clients, that, while this was incredibly disruptive, at the end of the day, it did not result in, sort of mass layoffs or even mass furloughs. But we know that it's nonetheless always a headache for HR. And by the way, let's hope, because if I'm not mistaken, this only goes till the end of January. So we're back doing this again. We will be boycotting,
Maybe a bold statement, but I think the people down the street downtown learned a lesson that nobody wanted to avoid.
We will be doing this from the back of American.
Good. Well, luckily they never go into a non-funding situation. We're always up to their bar.
Great. Well, as far as some other topics, I know with EEOC, there've been some other changes that come out that you guys wanted. I know we wanted.
It's actually just directly related to the shutdown and the reopening of the government, because while we keep hearing about all these different priorities that the Equal Employment Opportunity Commission is going to be employing under its new administration leadership, I mean, they really haven't been able to do anything really throughout most of this year. First half of the year, we had the DOGE cuts and trying to get Republican new administration commissioners approved. They have to get a quorum, so 3 out of 5 in order to act. They have not been able to act. They finally got the quorum right before the shutdown, and then the shutdown obviously interrupted any action. So they still have not flexed their muscle, but now they're right in a position to do so. They've got the quorum, and they've got very different priorities than the prior administration, and they are not afraid to trumpet those priorities, among them being that they are going to be, so again, they are the nation's enforcement of discrimination, gender discrimination, race discrimination, age, disability, religion. Well, what they're looking at very carefully is religious discrimination claims, whether it's anti-Semitism, anti-Christian, anti-Muslim, and they're taking very, very vigilant action. And that is not something that you saw in past administrations. I would say race and gender have always led the pack when it comes to EEOC enforcement actions. But I think we're going to see a big change when it comes to that.
Yeah, I think that there's going to be a major shift in the EEOC that will change and gradually, or maybe not so gradually, go away from just being kind of the stuffy, bureaucratic piece of the federal government, where it's just a place where complaints go into a black hole for a year or two, into an agency that's going to be more active, more proactive, that will show real changes from the prior administration. There's going to be aggressive enforcement against DEI positions. There's going to be pronounced activity against the kinds of actions that were much more pronounced under the Biden administration. So that's going to really be a very marked change. And we may not really see it start to pop its head until after the new year, because we're about to head into the holidays. But that's a really big change. And I think you'll see something that will be relatively new, which is a much more activist EEOC with a whole new set of priorities.
Yeah. One other area that they are focused on is the Pregnant Workers Fairness Act, which was passed and provided a lot of protection for pregnant employees. For the longest time, there was a question of whether or not pregnancy was considered a disability under the Americans with Disabilities Act, because it is a temporary condition. Certainly some of the medical impacts of pregnancy would be ADA qualifying. The Pregnant Workers Fairness Act came in and said, listen, that all has to be accommodated in America's workplaces. What happened, though, is with every legislation is The Democrat administration came in and said, we're not only going to cover pregnancy, but we're going to cover things like abortion related. We're going to cover infertility. We're going to cover things like menopause. This administration has indicated that they believe that they've expanded those particular aspects beyond what the Pregnant Workers Fairness Act was intended for, and they're going to look to curtail things like that. They're going to say, you don't have to accommodate for somebody who is going to get an abortion. You don't have to accommodate for infertility treatments, and you don't have to accommodate for an employee who's going through menopause. Now, this is what they've stated. They haven't done it yet.
Now, and although some may say that that sounds controversial, there's an argument to be stated that all they're really doing is they're just enforcing the law. They're just trying to ratchet back in a prior administration that some would argue, I'm not going to throw an opinion out and I'm not trying to be political, but some would argue that the administration earlier had tried to expand beyond what the law actually requires. Also keep in mind that the Supreme Court did away with the so-called Chevron doctrine, which allowed for kind of a super bureaucratic fortress of agency decisions where it's gone back into trying to hold to the core true meaning of what are the core elements of what Congress intended. So there's going to be a more conservative aspect from the EEOC positioning in that regard. But as Declan said, they're going to be leading into some other pieces much more aggressively.
And you guys also see maybe some changing new priorities as it relates to the National Relations Labor Board as well as we kind of come out of this. What are some things that are probably important for our listeners?
Yeah, so like the NLRB is the second agency that also impacts workforces. We did a bunch of these roundups during the Biden administration where the NLRB was really one of the more potent agencies, frankly, more so in my opinion than the EEOC in the last administration. They largely are associated with union activity. If you have SCA contracts, that certainly would come into play. But they're more than that because they really can reach into every private workplace. And what we're already seeing is legislation from Republican politicians that are trying to curtail the powers of the National Labor Relations Board. They're basically saying that it's not going to be so easy to file an unfair labor charge. Frankly, you can be fined. I think it's up to $5,000 per unfair labor if it's deemed to be frivolous. In the past, it's been very easy. I've seen it many, many times with clients where you just fill out a form and you send it in, and next thing you know, you're under investigation. So they're taking aim at that, definitely.
Well, let's jump into the performance topic that we mentioned. We're getting here at year end. I think just to start off, Seth, just from a high level, or maybe in a format and a structure and a best practices, what are some of the things that our listeners should be thinking about as they look to put these these efforts into place?
Yeah, so we're in performance evaluation season, and I think that the key is to not have it be complicated, to try to keep it simple so as to not overcomplicate the process, and to make sure that when you're getting the HR leaders involved in the process, that they coordinate with frontline supervisors so that it is an integrated collaborative process rather than something that is imposed from above. So there is an encouragement to keep it regularized, simplified, coordinated, and there are a number of storage and retention requirements that I think are worth noting because, these sound like they're a little bit antiseptic and a little bit complicated, but I think that they're intuitive, and I think that there are things that are actually very simple and that are specifically geared towards assuring best practices for the protection of the company. So there's a Virginia regulation, Title 12 of the Virginia Administrative Code, 35-105, relating to employee and contractor personnel records. The employee and contractor records under the Virginia Administrative Code have to include various elements, and they're pretty basic, but they're important. Personally identifying information, education and training history, employment history, disciplinary actions. The records under the local regulations need to be maintained for a period of 3 years after the term of employment has concluded. And these are things that, again, they're really considered best practices and are things that will certainly accrue to the benefit of the employer. There's also a relevant Virginia statute, Section 801-413, regarding copies of employment records, the right of employees and legal counsel to access copies of the records, and the handling of costs and attorney's fees. There are similar requirements with regard to statutory requirement to maintain current and accurate employment records. The employment records need to be able, as a matter of Virginia statutory law, to be accessed by the employer and his or her attorney. And on a request to access the records, the employer has to provide access to those within a period of 30 days. So again, rather intuitive, shouldn't be overly complicated. There are related EEOC requirements also for record and maintenance requirements. That's under Title 29 of the Code of Federal Regulations, which require retention of complete employment records, including records of any pending charges. So what the EEOC requirements do is they basically codify what we lawyers call a litigation hold. If there's any kind of a formal or informal allegation or charge, there's a requirement under federal law that the company preserve and maintain essentially a hold on all of those records. So again, these are basic requirements, things that are really can be considered as guideposts. It's not critical that evaluations be signed. There's no technical requirement for the signing of an evaluation, but I think it's probably good practice. I'm wondering, Declan, what your opinion is with regard to the protocol and someone signing or maybe even refusing to sign a performance evaluation.
One thing that's interesting too is, with the advent and the development and the enhancements in HR technology platforms,
Right.
In my world,
Right.
has really, it's funny, we've always looked at it and with our clients and the HR professionals is, hey, providing them resource and tools and interfaces to enhance the experience, make it easier for managers, making it, better, experience for the employees, not be a paper-based process. Never really thinking about the legal requirements of maintaining all of that information, which also it just leads to making that more efficient.
Well, yeah.
More hitting that requirement. Yeah, so that's the whole point of that we might even kind of thought about in that process.
Approach is not only good from the electric keeping and from the efficiency requirement, but you're helping keeping companies out of trouble.
Yeah,
because you're allowing them a means to more readily comply with all these requirements.
Yeah.
Yeah, I mean, I've seen so many situations in the past, and I think that you're right. These platforms have largely rendered this issue more moot, which is, hey, you didn't sign off on your performance evaluation, or you didn't do X, Y, and Z. And there is no requirement to do so. And sometimes I've had these conversations with HR professionals where they say, well, it's not a valid review if it's not signed off on. That's not true at all. I mean, all you're really doing is telling them, you just need to show that they've received it. And in today's day and age with these platforms, they provide automatic notifications, things that...
And most of them have a electronic signature. To everybody, acknowledge that it was done in its date stamps. You can do that as well. So again, just simplifying the process, and even a lot of times allowing, especially in our government contracting world, we see a lot of times that the ability to get feedback from people who maybe are on the contract or at the client, but aren't directly part of your organization, and bring in third parties and add that to the process also just enhances those capabilities in that process.
Absolutely. So it is something that is really beneficial to both the employer and the employee. It maintains a consistent channel of communications, guidance, and achievement of goals at the organization.
What about the age-old question of what's the recommendation to employers when an employee challenges the result of their evaluation? Not happy with that.
Yeah, I don't see a problem with that, because I think sometimes when there is a negative evaluation, I think it's good to give a platform for communication and for, frankly, preventing. So often in my world of litigation and employment, disputes, it's oftentimes because the employee feels they weren't heard. And these platforms that, again, you're in your world, you deal with these all the time at GovCon. the platforms usually provide a feedback narrative, area of it where they can. And it really, at the end of the day, it doesn't change the evaluation. It's the employer's ability and right to dictate like how they feel somebody's employee, performance is. And so just because somebody writes back, now, every once in a while, they'll write back something and say, well, it's because I feel like I'm being unfairly targeted. And frankly, it's a hostile work environment. Then you got an issue, and then the HR folks, jump into action, spring into action, and have to look into that. So this two-way dialogue is good, and it can also have its downside, which is it makes the dialogue a lot more back and forth, and it makes HR's life sometimes a little bit more difficult with all this free flow of information from the employee.
And what we're seeing as well, I mean, we're talking about it, in the context of year-end and year-end performance evaluations. But I think what we're seeing from a lot of our clients too is people are getting away from the one-time year evaluation. We're doing this, again, having communication throughout the year. Technology platforms enable for that type of communication, goal setting, checking it, those types of things to all lead to those better outcomes.
Yeah, Seth said at the very beginning, we're entering into performance evaluation season, and you're right about that. I mean, we go through that and everything. But what's interesting about that is I suspect that a lot of listeners heard that and said, I hope that this season has been starting in January and now will just culminate here in coming up in December, like it really should be. And in fact, I'm going to jump ahead a little bit because I think it's an important thing to the last topic, which is how frequent should you do them? It's not just that you do these at year end. They really should be a continuous process throughout the year. I was reading something interesting. It was in SHRM, and it's being advocated by one of the SHRM columnists, and they call them same-day summaries, SDS, because everything's got to have an acronym. And what it is basically after you have, let's say, a meeting. It doesn't have to be some formal counseling session with an employee. You have a meeting with somebody. Instead of sending the typical CYA email, you send an email recap back to that employee. But it's a lot more productive, and it's like, how can we let's acknowledge the problem, but let's see how do we move past this. And it's a lot more I would say productive communication that's happening. Now, you are creating a record of counseling throughout that process, and it's a real-time record. It's not at the end of the year where somebody may have had 3 supervisors over the course of the year, and you're trying to figure out, hey, what kind of employee what kind of issues, and by then they're gone, and it's really an inefficient process if you're just scrambling at the end of the year. I suspect most people listening here probably have moved away from just doing these either once a year or semi-annually, and they have employed more of a continuous year-long process of back and forth communication with the employees.
Well, I'll bring us back to the next thing, which kind of ties into those conversations of constructive conversations and about performance. And everybody hates the term PIPs and performance employment plans. But it sounds like they have particularly maybe come under some scrutiny as far as how they're implemented, how they're seen from a legal perspective, maybe created issues for companies on how they've implemented them and them. So if people are utilizing those as tools, what are the key things they really kind of keep in mind to make them beneficial and obviously get the outcome that you want from it, but also not create additional challenges?
Yeah, there is a place for a PIP. I mean, I'm generally not the biggest fan. My clients know that, I'll really hammer them to say, do you really think that this employee has a chance to make, to improve? Otherwise, I saw something on, I think it was on LinkedIn or something, where somebody just said PIP equals punishment in progress. And I was like, you know what? That is so succinct and so absolutely true. And so that's the problem, is what happens is people think like, this is just the last step before I'm out the door. If you're using them for that, you're using them the wrong way. You don't need to do so. You're going to probably, force your employee to go maybe talk to a lawyer, and then they may come back with some kind of a claim of unfair targeting. And next thing you know, you're worried about, if I terminate, is this unlawful retaliation? So it could be creating a little bit of a predicament. The courts are starting to really become wary of PIPs. They know the game. They know the game that a lot of people use for them, that this is kind of the last step before you're going out the door. And there's been a number of cases. There was a case coming out of New York recently where the PIP required, it was a 2-week PIP that required the employee to complete 5 major projects in that 2-week period. It turned out through trial that would have been basically an impossibility, especially to do it in a satisfactory manner to overcome the PIP. And so the court basically said, like,
Punishment in progress.
yeah, that definitely was punishment in progress. And so the court just said, you know what? I think that this PIP was really just a pretext for unlawful discrimination. So the company might have done the PIP to protect themselves from wrongful termination. In the end, they set themselves up the exact opposite.
I'm going to look at it a little bit, maybe too bluntly, but my approach on PIPs is why bother? To me, PIP equals no good deed goes unpunished. If you have at base 99% of the time an employment at will relationship, but yet when you're establishing a PIP, you're creating an artificial layer that's transposed on top of it, where you have a new set of dictates and requirements that's basically a pseudo agreement to be able to track an alignment of progress. And as Declan said, you have these cases that have come out in 2025 that have basically opened the door for courts to come in and for judges to micro-assess and micromanage. Well, how fair was it? Was it fair? Was it reasonable? Was it manageable? Was it doable? And then you get the plaintiff on the stand after the avoiding motion to dismiss saying, it's totally unfair and I was treated differently than Mary or Joe. I am not a fan of PIPs, and I rarely seen it being a good idea versus just having a counseling session without referring to it as a PIP. But I know Declan.
No, I think, and remember, PIPs are not done in a vacuum. It's not like the employee's like, oh, I just got a PIP. They know the history of the company. And if the company has used PIPs the right way, if they have used them to create success stories in their employee ranks, then that will not cause consternation. Right. But if it has been pretty much that every time someone's on a PIP, if 30 days later they are out the door, everyone's going to know. So they're not done in a vacuum. Actions speak louder than words when it comes to how your company operates when it comes to PIPs. Yeah, we can't end. We only got a few minutes left. We can't end on such a down note. Come on.
No,
Thanksgiving's coming up here.
So we'll go a little rapid fire with our kind of last topics. So Seth, we'll come back to you. Just talk about like if generally in kind of best practices as far as who's involved kind of in the process for the performance reviews. What are the key things to consider?
Consistency, predictability, communication, collaboration. Have other people, aside from the HR managers or ops directors involved in the process, have them be applied consistently across the board in collaboration with managers for consistent feedback and transparency.
Yeah.
And job descriptions. Keep them up to base and making sure that your performance, there's alignment there. What are the key things that our listeners need to keep in mind there?
Yeah, I was in a meeting with a client today, and we were talking about this very issue of job descriptions, because I sometimes feel like job descriptions are something that happened at the very beginning of the employment relationship, and then they get into the proverbial, desk drawer and gather dust or whatever. And then when there's an issue, if you're looking to ding somebody on performance, they can very well weaponize that, come back and say, that's not in my job description. And we all know that job descriptions change over time. And your job description, if you're at the company for 5 years, my goodness, what you were hired for back in the day. So you really do have to keep track of those. And I think that these, again, it goes back to these HR platforms. Yeah. Nowadays, it's very easy to do updates to job descriptions.
As practices once a year, then everybody should be looking at those job descriptions.
I think once a year is probably fine. I mean, you could argue that more, you do it more frequently, but I think HR folks are already overloaded these days. I think once a year is fine. Yeah.
Great. Any other closing general comments with regards to this topic, or?
No, it really, I guess I would say performance reviews underscore the number one issue when it comes to employee relationships, which is communication. Yeah. So how you do it, if you really just impose this number system, I always see these 1 to 5, 1 to 10, usually it's 1 to 5. And it's like, I don't know, I find it very impersonal. I know that that's the way most of them are done. So I'm not suggesting we throw all those out. But like, do you give somebody a 2.5? Do you give them a 3? Is a 3 good or is it bad? It's like,
long definitions of what a 2.5 is versus 2.
Yeah, exactly. And so when you're doing it just based on those numbers, you're not really effectively communicating with your employees. And that's what the name of the game is anyways.
All right. Well, gentlemen, it's always been a pleasure. Want to thank everybody joining us old school today in the conference room. Hope you're able to hear us and follow us just as well as them.
Look very powerful underneath the nation.
Yeah, look at that.
Yes.
This is not a sign of running.
And the lights behind me. None of it you're taking. But then the whole thing up.
Well, we flipped the switch there on. It's interactive. Yeah, this one a couple of days ago, actually. So, but again, thanks everybody for joining us. We hope everybody has a wonderful, safe, and joyous Thanksgiving holiday next week. We look forward to seeing you in December. We don't know what our topic is as usual. We're going to continue to keep it timely, but we'll make sure, obviously, we come hopefully with some helpful information. Again, safe holiday season. We look forward to seeing you next month, and take care.